Good afternoon, everyone. Here I am once again doing my Facebook challenge, live challenge actually. So this is LaQuitta Joseph again with LaQuitta Joseph Enterprises. So today I am talking about probate once again, and today's topic is about what happens if someone contests a will, and also who can contest a will. So who can legally contest a will is only someone who is an interested party. So they have a vested interest in the estate of that deceased person. So there are three types of people who can contest. Those are your beneficiaries of a previous will, or beneficiaries of a subsequent will, or intestate heirs. And intestate heirs really mean someone that was named, in the will or a previous will, and who would inherit or maybe fail to inherit, under the will if it's deemed invalid. So I hope you got all of that. That just means, if you can prove that you were named or should have been named, or you show you would have received something from the estate if the decedent had died without a will. Okay, so that's a mouthful, right? That's a big mouthful. So beneficiaries, they were either previous, so meaning someone had a previous will, maybe there have been multiple or subsequent versions of a will. And so maybe they were named in one or the other, or you believe that you were left out of that will inadvertently. And also when we talk about heirs, so heirs are those who are named when there is no will, intestate. So you've heard that term before. I've used that term, intestate. So that means that they die without a will. But when they die without a will, then the process for probate goes through the Georgia probate court process. So where the court actually determines who receives what, based on the fact that if they were heirs. And so in this case, heirs could contest because the heirs are really going to be either spouses, children, parents, grandparents. It could be adopted children, siblings, any of those people could be heirs to someone's estate. And if they were left out, right? So someone that is an heir and they feel like they were left out of the will. So say there are 4 children, but only 3 children are being named to receive something. And so that can be contested by a 4th child, or maybe there's an adopted child that somehow the courts wasn't aware of or not, privy to that particular information. So therefore, you can contest that will and contest that. So what actually happens when someone contests a will? Well, first of all, if they contest it, then that's going to be a costly process because you're going to have to get attorneys involved and the courts, and then that's going to be time consuming as well because they're going to draw it out. Each side is going to argue their case basically, and it takes time because those attorneys, have to do their research and investigations and to determine whether or not there is a valid contest. So, second of all, so the person who does contest the will, they would have to show that they have grounds to contest that will. So they'll have to either through testimony of others, maybe witnesses of such, or evidence that proves that they are also an heir to that particular estate. And then finally, after all of those things, ultimately, the probate court is going to be the one to decide whether or not that this person who is contesting the will, whether it's a valid contest or not. So I hope all this information was helpful. If not, you can rewind this again if you missed something, or if you just need to understand a little bit more. I went through it too quickly. Please DM me. That's okay. I appreciate that. Just DM me, let me know, or ask me a question. I'd be happy to help. Thank you, and I will see you again tomorrow to continue my Facebook Live challenge. Thank you, and have a good evening.